Article 144(2) of the 1992 Constitution enjoins the President to make such appointments to the Supreme Court on the advice of the Judicial Council in consultation with the Council of State and subject to parliamentary approval. In the wisdom of the framers of the Constitution, this consultative process is designed to protect the independence of the judiciary. Contrary to this constitutional imperative, the Chief Justice singularly constituted herself into the Judicial Council and unilaterally acted in his name and on his behalf. By electing to write to President Akufo-Addo, requesting for this appointment and seeking a post facto ratification from the Judicial Council, the Chief Justice sought to turn the Council into a mere rubber stamp. Nowhere in the Constitution is the Chief Justice named as the one to recommend persons to the President for appointment to the Supreme Court. We wish to state, without any equivocation, that the Chief Justice's letter is illegal and of no effect. Her actions have completely turned the due process on its head and compromised her independence as the head of the judiciary. We are concerned about a worrying pattern which irresistibly suggests that the President is appointing only loyalists of his party to this court to have control of the judiciary and escape post-regime accountability. It is also very clear that the President is backing the courts ahead of the impending presidential and parliamentary elections with judges who are sympathetic to his party. Such deliberate politicization and bastardization of independent institutions of state, including the judiciary, will negatively impact the peace and stability of our country. It is tried knowledge that without a fair and impartial judiciary, democracy and constitutionalism will suffer. That is why this must be an issue of huge national concern, as it adds to the many other issues that already pose big threats to the peace and stability of our democracy. Already, President Akufo-Addo has appointed as many as 15 judges to the same Supreme Court since 2017. This exceeds the 7 appointments made to the Supreme Court by both President John Evans Mills and President John Mahama over the 8 years of the NDC. President Mills appointed 3 judges to the Supreme Court, while President Mahama appointed 4 judges to the Apex Court. If President Akufo-Addo and the Chief Justice are not restrained in their unholy alliance to appoint 5 additional judges to the Supreme Court, it will bring to 20 the number of judges appointed by President Akufo-Addo alone to the Supreme Court. While the Constitution of Ghana does not put a cap on the number of judges to be appointed to the Supreme Court, it is very clear that the framers had operated on a reasonable assumption that all presidents will be mindful of endless appointments to the Apex Court and its consequences. The framers of the Constitution clearly did not contemplate an Akufo-Addo presidency, where the Apex Court will become packed with loyalists of the president and his political party. With general elections set to take place just in a few months, we are of the view that President Akufo-Addo must immediately halt his plans to make any further appointment to the superior courts. This is in view of the fact that he has already packed the court with too many of his loyalists, to the disbelief of many right-thinking Ghanaians and consummate Democrats. Again, there are enough judges on the bench at this particular point in time to deal with the judicial issues. More importantly, with elections on the horizon, it is fair that any such appointment with far-reaching implications on this constitutional democracy should be left to the next president of the Republic of Ghana. And this is common practice all over the world. It is only under Ghana that this is being put on. After all, President Akufo-Addo has already abdicated his position as president a very long time ago when he declared that the next president will fix the economic needs that he and Vice President Alhaji Bawumia have created. The president must be reminded that such long-sighted appointment, particularly to the judiciary, is a big factor in the widely held perception of a politically biased and hostile judiciary in the administration of justice at the apex court, especially in matters involving the ends. President Akufo-Addo must therefore take a cue and desist from any further appointment to the Supreme Court at this time in order to help de-escalate the perception of bias on the part of the judiciary. The latest maneuvering between the Chief Justice and the President adds to the series of happenings in the judiciary that paints a picture of bias and imbalance. Further packing of the courts will do very little to restore trust and confidence in the judiciary, which already is at an all-time low. It can, in fact, fuel legitimate concern that it is being done to ensure the presence of an overwhelming number of judges who are sympathetic to the current regime, who could be called upon to shield members of this government from scrutiny and to frustrate any future effort at exacting accountability from them when they leave power. The NDC finds the retort by the Chief Justice that the latest abortive appointments were necessary because of the load of cases to be completely untenable and without. Furthermore, we have noted a trend of very speedy promotion of relatively newly minted judges over and above their more experienced seniors at the bench. This undermines the spirit of meritocracy, which is essential for proper administration of justice and holds the potential to pressure such judges into delivering rulings that may catch the eye of the appointing authority. Also, the unexplained transfers of some judges in the immediate aftermath of their judgments in high-profile political cases raises eyebrows. The impression created from this is that judges who do not conform to some expectation of the Chief Justice and the President will receive subtle retribution cloaked in administrative processes for their troubles. Democratic governance requires that certain standards are met within all arms of government. At no point must independent institutions of state be joined at the hip with the executive to further its interests. Friends from the media, the current posturing of the Chief Justice and their involvement in the nomination of more judges to the Supreme Court do not inspire confidence that the judiciary is sufficiently independent from the Akufo-Addo Bawumia